Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am honored to have a brand new guest. His name is Judge David B. Katz. He is the president of the National Council of Juvenile and Family Court Judges, NCJFCJ, and is the presiding judge in the family division in the Essex Vicinage of the New Jersey courts. The NCJFCJ's mission is to provide all judges, courts, and related agencies involved with juvenile, family, and domestic violence cases with the knowledge and skills to improve the lives of the family and children who seek justice. Judge Katz was appointed to the Superior Court of the New Jersey in 2008. Judge Katz is chair of the New Jersey Supreme Court's Family Practice Committee and the immediate past chair of the Conference of Presiding Family Judges, and in that capacity served as a member of New Jersey's Judicial Council. He has also served as the lead judge for children in court, lead judge for domestic violence, lead judge for the children in court docket, and the family drug court judge and the chair of the model court. He is a former chair of the statewide domestic violence working group, as well as the Essex County Domestic Violence Working Group. Judge Katz is active in his community, where he served 3 terms as mayor and 15 years as a member of his local emergency first aid squad as an EMT. I welcome you to my podcast, Judge Katz. How did you get so involved in all of this? Where did you start?
First of all, let me just say how nice it is to be with you, and thank you for your kind introductory comments. As we get into this a little bit today, hopefully I'll be able to convey my passion and love for family law. And the best way I think I can exemplify that is before I became a judge, I was a lawyer for some 20 years, and I never practiced family law. In my state, when you become a Superior Court judge, we have 3 divisions. Our judges rotate through civil, family, and criminal. I started in family. It would just satisfied me beyond words, the fact you could have an impact in what we do. I learned a whole new discipline, and it's been nonstop since. And I've been very, very fortunate that I've been able to get into some leadership roles and really feel that this is where judges can have such a significant impact every single day that we take the bench on the families that we serve.
Mm-hmm. Now, the training that you do, what type, how do you train these judges in the family court setting?
So nothing is really more important than training. Judges have a lot of discretion. In my state in particular, and I believe most across the country, these cases are not with a jury. So the judge is the fact finder. And that means we have discretion. Now, it's not unbridled discretion. We have an appellate division with very specific standards that they apply to review a judge's discretion. But judges really have to know what they're doing because of the impact. When we have a domestic violence case, if we don't handle it appropriately, you run the risk of re-victimizing a victim. You run the risk of empowering an abuser. We deal with the most significant cases in the whole judiciary when we talk about possibly terminating parental rights. We talk about custody, who's going to see their children, who's not going to see their children. All that has a dramatic impact on the children as they go through their lives, and then they become adults. And hopefully will be productive and well-grounded, et cetera, et cetera. So training is crucial. And we have a multifaceted training approach. That's basically what we do at the NCJFCJ. We want to make sure that, some states don't have the resources that other states have. In my particular state, in Vicinage, with 20 family judges. So when you have 20 judges, there's a lot of resources that go with that. We have judges across the country that may be the only judge in their county or Vicinage, and they don't have the financing or the training or the ability to go down the hall and talk to somebody about how to handle a case. So we have annual conferences, we have webinars, we have materials, we have published materials. we estimate about 10,000 professionals across the country. And that is, I'm glad you asked that, Marion, because that's really the core of what we do, is make sure that every judge that deals with these cases has the latest practices, is aware of the research, and has somewhere to go if they have a question. And then in conjunction with that, it's kind of an isolating job. You're by yourself, you're making the decisions, and we're very concerned with vicarious trauma. We're very concerned with the wellness of the judge. If you think of someone who perhaps in the medical profession and all day long they're seeing patients that are very ill, you start to think everybody's ill. It's because that's what you're seeing day in and day out, and you can't let that happen. And so our judges have to stay sharp. They have to, not get worn out with and we'll talk maybe a little later about the volume that we're seeing in our cases. So our education at the NCJFCJ also moves into wellness. The best example I have of that, if I could talk for just another moment about that,
Sure.
is you think about, those who've been on an airplane, and it's such a simple example, but they give you those standard instructions on what to do if, God forbid, there's an emergency on the plane. They tell you if the air masks come down off the ceiling, the first thing you do is you put that mask on you before you put it on the child. Now that's very inimical. Who would think that, if you have a child and we're in an emergency situation, you will put that mask right on that child in an instant? But the concept is you have to take care of yourself so you can take care of someone else. So I kind of adopt that thinking in that very simplest example to what we're teaching judges also, is the wellness. You're doing something important. We need the judges to resolve these conflicts that the families can't resolve themselves, but you have to be well and able to do so. And so our training goes into things like that as well. A couple of years ago, that wasn't on the table. Now it is.
Have you ever had a judge come to you and say, this is burning me out?
All the time.
Oh.
So, again, I'm fortunate because I have 20 judges that I work with here, 20 in my in family alone, 60 across all 3 divisions in my own little world, my own little corner of the world here. So we have that ability where we can meet weekly. But I am very concerned that, I'm in a large metropolitan city. I'm very concerned about folks across the country that deal with the same exact cases I deal with that don't have those resources. So we make sure that when judges join the NCJFCJ, they have mentors. There's someone from their state from our membership committee that will reach out to them. We invite them to conferences. We try to, bring them into the fold so they can talk and sound out what they're doing. And then another thing we do, which is kind of fun, is that we try to have fun. So that we, we'll find a sporting event in the cities that we have our conferences, so we can get a large group of people to do that. We have wellness. There's yoga in the morning and walking and exercising. And then, we'll also get in some speakers who will just talk about trends, interesting things in the law and expectations with the court term and what we can expect and things like that in the future. So there's a lot of things like that, Marion, that we try to do to address the burnout and things that can follow from that.
Do you ever have judges go through a psychological eval every other or every 2 years, something like that?
No, we don't do that. I know. So in the first instance, to become a judge is different in every state. Some states, like mine, you're appointed by the executive, and you have to get confirmed by the Senate. Other states, you run for office. And so in states where you're appointed, perhaps there's a little bit more control of who they're going to nominate and how they're going to nominate someone. So they could require perhaps physicals and things like that. I don't know how they would work necessarily with someone who wants to run for office, judicial office, but that's part of the job of a presiding judge. I have ears in all the courtrooms in this building. I have access to, we use what they call a court smart system in our jurisdiction and in others. So I have access to all of the proceedings. And if I have a litigant that feels a judge didn't do something appropriate, I get letters, and that's not uncommon. People have certainly a right, and they feel they weren't treated appropriately or properly. They could certainly and have every right to voice it. They can also appeal it. And so we constantly are able to look at and review proceedings, kind of like check in, and across the country, judges can do that. And we also tell judges, you have to do a lot of self-assessment. You're in a particularly tough case, and you find yourself, you're raising your voice a little bit, or your heart's beating a little quick here, or you're a little quick on cutting someone off before they had a chance to talk. We try to teach judges to recognize those signals so that they can take a break, regroup. I don't want to say we're only human, but we are, and we are subjected to emotions, and in some of our dockets we see pretty bad conduct, and not that they're bad people, but people doing not nice things or appropriate things, and we have to deal with it. So yeah, we really, Marianne, really try to focus on making sure that we're watching each other and have each other's back in that regard.
When these cases come in with domestic violence with evidence, I'm seeing a lot of cases where judges aren't even looking at solid evidence, and then they hand the child over to the abusive partner or ex. And so why are judges disregarding evidence?
Well, I would hope no one is affirmatively doing such a thing, because you're not fulfilling your obligations. You have to consider even arguments you don't like. You have to consider and weigh them. And it really gets into due process also. If people have something they want you to look at, you have to look at it and rule on it. And a lot of that may be a training issue, what you're referring to. And it's our job in leadership to make sure judges are appropriately trained. And it's something that really has enabled the NCJFCJ to be so successful over 85 years as a technical assistant for many of the federal programs. We are the providers, the technical assistance providers, so we can get into courts and help train. It's really one thing we also do that at the NCJFCJ, we try to bring real life experience to our conferences. We can be in courses and teach each other, but until you really hear from somebody who's been through whatever it is we're talking about, and understand their perspective, how they came away, what the approaches were, were they listened to, were they not listened to, then you really have an impact on addressing some of the things that you're talking about. I will tell you, sometimes judges are pressed for time. I tell our judges no shortcuts. You can't take any shortcuts here. So if you think you're hearing something that you don't want to hear because I don't have the time for it, it's not good. You gotta make sure everybody has a full and complete opportunity to present what it is they want to present. Can't prejudge it, but at the same time, when we have a case, there are certain things we need to get to see if we have a meritorious case or not. And so it's a little bit of balancing, and I think really a lot of this that you're addressing is a wonderful way, I think, to address it is through the mentorship. Have other judges listen to your tape recordings. So, when we have a proceeding, go to a more senior judge. I do it on my own because I have a structure here. But if I was somewhere across the country, we'd want to facilitate where someone, for constructive help, that's all, and confidential, we're not evaluating, we're not grading the judge, but just to say, you may have wanted to do X, Y, and Z. It may have led to a different outcome and things like that. So a lot of that are ways we can attack what you're talking about, for sure.
Now, I'm hearing, and I don't know if you're hearing this too, but when a victim calls out domestic violence, then the other side calls out parental alienation, which is technically child psychological abuse. And it seems like the opposing side will call out parental alienation even if there's no proof of this, and they'll run with it and drive it into the ground so that parent loses their kid. I don't know if you've...
A lot of things can happen here. Yes, sometimes we see a counterclaim. I did not. Not only did I not abuse you, you abused me.
Mhm.
So you'll see a filed counterclaim. You also see calls to child welfare agencies, and they're obligated to investigate. And obviously, we want child agencies to investigate calls, but we don't want them to investigate spurious calls.
Mhm.
What you're touching upon is a real concern, because a lot of the individuals in these cases are self-represented, and so there's not a lawyer that can defend against what's coming. And judges have to get to the bottom. We really sit right in the middle of the room,
Mhm.
one side or the other, and there's a balance between making sure people have a right to say what they want to say,
Mhm.
but also making sure that we're not re-victimizing victim. A lot of times, I will think back, and we can talk more about the parent alienation, because it's certainly something that, what's the expression they use? Sometimes the best defense is a good offense, or something along those lines. But sometimes you'll have, no question, there was an altercation, no question, but was the one party defending his or herself?
Mhm.
So we want to resist. Well, you both were fighting. You're both getting restraining orders against the other. There are implications if you restrain someone. Plus, the true victim was not validated,
Mhm.
and so you have to be very, very careful. Even when you enunciate your decision on a domestic violence case where you don't find DV, you have to be very careful that you're not. You're human. You may have missed something. You don't think you did, but you have to be very careful that you're not giving someone a green light.
Mhm.
And so we are very cognizant of the dynamics, and we have an open court system where people can claim what they wish to claim. Has to be in good faith, but out of the box, you don't really know if it's good faith or bad faith, so you have to entertain it. And I think, Marianne, it comes down to education and experience. You get a flavor. We've even studied situations where part of the abuse that's hoisted on a victim could be feeding a drug habit, encouraging drinking.
Mhm.
And then when they come into court, you have someone who's the victim, but there could be things that could affect their credibility. But it's all part of the coercive control that created the situation where we are. And so we're not psychologists. We study as much as we can, but we have to always be aware of the dynamics of domestic violence through training, and how an abuser, it's not just slapping somebody. There are many, many forms of abuse. And, in the old days, I don't see any bruises, you seem to be okay. You wouldn't get your restraining order, I guess. That's not where we're at today at all. We understand that there are multiple forms, and especially a carefully controlled abuser can, sit in court very calmly, dressed to the T's, come across as very credible, and the victim who has been abused is afraid he or she may lose their children, afraid no one's going to believe them, and so they're coming across maybe repeating what they're saying or not answering a question, and a untrained judge could say, well, one's credible, one's not credible. I don't have a videotape of what happened here. I'm just going on credibility. So we really try to make sure that judges understand red flags. They understand indicators, and that they're just aware that you've got this case in front of you in a formality of a courtroom. Lawyers aren't presenting it, but you have to really try to make sure you're hearing and looking and observing what's being said, how it's being said, etc. But you're absolutely correct. We have many instances where both sides will be alleging horrible things against the other side.
And again, the hardcore evidence, and they've got pictures of bruises and police reports. So, with all of this, why doesn't the judge stop the proceedings? Like, even if there's a recording of the person who is intoxicated threatening to kill a couple of people, and why not stop the proceeding and just call the DA and move it into criminal court?
Well, that's a very good question, and an interesting one to approach, because a lot of domestic violence is physical assaults or some other criminal offense. For many reasons, some victims would rather have it resolved in a family court than a criminal court. But I believe the role here is, what's very important is, and we advocate for this as much as we can, is to have advocates speak to the victim. Some states, like our state, we have a domestic violence response team that will respond to the violence and pull the victim aside to, the judge can't offer that. Let's sit around the table and let's talk about things, but advocates have to be in the process. A litigant may not even know what they're supposed to tell the judge. One of the things we talked about red flags. One of the red flags is after we enter a restraining order, it's a two-part process. You get an emergency temporary order, then you have your trial. Is that they may have breached or violated that restraining order. That's an out of control defendant. Even if the court enters an order saying stay away, they're not staying away. But I would only know that if the victim told me. And they may not know to tell me. They may be more concerned with the fact that, he's telling or she's telling they're going to lose their children or things like that. So, Marianne, what we need to do, and our organizations, understands this, is make sure that advocates are in this process, because they are the ones that will explain that the prosecutor, we may want to file a police complaint, etc. Judges have the ability to refer a case to the prosecutor. I know in our child welfare docket, our prosecutor in my particular state looks at every complaint that comes in. They're all looked at when the prosecutor has his or her discretion on what they want to do. So sometimes we have cases proceeding on parallel paths. But we are most concerned with obviously the victim and the children. What are we doing about custody? I don't want a criminal judge, with all due respect to my criminal colleagues. They have certain interests that they're focused on, and they're important. We focus on the children in those situations. And our court rules even talk about the potential of who should make that decision about what's in the best interest of the children when there's a family case and a criminal case. In our court rules, I never really studied across the state. We grew up in our own jurisdiction. Until you get on something like the National Council of Juvenile Family Court Judges, you start to realize there's a whole country out there. And our way isn't the only way. But what we do, and again, I don't know if other jurisdictions have looked at this and do it differently, the family judge controls that decision about whether there's going to be contact with the children and things like that. Criminal court, yes, you're not going to contact the victim. You're not going to contact any witnesses. You may have to wear a bracelet, whatever it is. But when it comes to the children, we're in that equation. So there has to be cooperation between the criminal and the family court for what you're talking about. Sometimes cases have to get reviewed. Sometimes a victim may not want to go to criminal route, but I think if they're talking to an advocate, they can get a more fuller explanation of how to take care of themselves, how to protect themselves. We'll give them a court order, but there's safety planning they need to do. I'll tell you, Marianne, that when we enter a restraining order against a defendant, that's one of the most dangerous times for the victim, because the defendant's been outed. He or she's been getting away with this. Now they finally had the courage or the ability or able to come into court. They were able to break free, if you will, come to court. Well, a controlling defendant, is now, I think, really a real danger, more, to do something because he or she's been outed and they're coming to court now. So advocates have to really get in there, and we have to make sure that the victims understand and know how to do what they can do on their own with family members, with safety planning, get themselves to a safer place, have a buddy, things like that. And so when we have our conferences, we try to do a holistic approach to something like domestic violence, so that it's not just coming to court, tell me your story, and you get a restraining order.
When you say advocates, could it be an American disability advocate?
Well, so we again, I would just tell you, in our jurisdiction, and we're by no means the only jurisdiction, but we decided that we'll find members of the community who are interested, and they get, I think, a 40-hour training program, so they know what they're talking about. Because obviously you don't want to put someone in a room with a victim and not be what the victim needs, and not being aware of the services, and not being aware of the questions that they have to try to elicit. So we have a 40-hour program that we will use for advocates. And again, I'm very sensitive that I have the fortune of being in a location with resources. Not like that across the country. And that's what we try to do with the NCJFCJ, pardon me. We try to make sure that every child, it's just what you read in the beginning, the mission is to provide all judges and courts and related agencies with the knowledge and skills to improve. And that's our mission. Our vision is to have a society where every family and every child has access to fair, equal, effective, and timely justice. So it's not just, the Chicagos, the New Yorks, the Cincinnatis, the Dallas, those jurisdictions that have, resources maybe that they can that they have developed. We have to make sure we're not resting, if you will, until every jurisdiction has at least access to the latest research, the latest teaching, the best practices, and help it. We just want to help.
I've been following a case that I had this father on, Jim Schock, and he had a judge strip him of his Second Amendment rights. He's had no parking ticket, nothing. He just wants to have access to his child. And there's a judge.
Let's not mention any names, though. Go ahead.
Oh, that's okay. No, he's been on my podcast. He won't mind. But what why do these judges, feel they can take away someone's Second Amendment rights when they've never ever done anything?
You're talking about guns, Second Amendment guns, or parental rights?
The guns.
Guns, sure. Well, I think the way we work as a judge is we don't make the law, we follow the law. So, different legislatures in different states obviously have enacted different gun laws. Some states are more in one direction versus the other. But again, a judge has to, I believe, undoubtedly follow the law in the first instance. Secondly, explain his or her decision. If I'm going to do something, I explain why I do it. because that's part of due process, so that, every trial court's decision, you're talking to a trial court judge, every trial court decision, as far as I know, is subject to review with appropriate, mechanisms to get to what we call the appellate division. So I tell all the litigants, there's a court that sits above me, and their job is to review trial courts. Did I make a mistake? I sure hope not. Is it possible I made a mistake? It's possible. I certainly didn't do anything intentionally, but I may have misread something. I may have misapplied something. So there's always that right of appeal, and that's a very important part of our process. So that they don't have a rogue judge, so to speak, at the trial level. That he or she has to follow the law, and they know if they don't, there's a higher court that's available. So whenever someone does whatever they're doing, there's two things that lead to it. What is their interpretation of the law in that state, and how are they viewing the facts? What caused them to do what they did? And I think it's very important. And whenever I get a chance to teach, whether it's in my state or across the country, it's those two things. It's like the two check boxes. You got to check those two boxes, because that's a due process right. It's an access to justice right, and it's the way our system is built, so that people just don't say, well, the judge likes people in a blue shirt, and therefore the judge went that way. They have a right to know what's the source of the law I'm relying on, and what facts I'm using to get to where I got to.
Okay, so when it comes down to this child psychological abuse, this parental alienation, it seems like the courts are abusing the term to, they've got these bruised egos, and they're using parental alienation to take someone's kids away because that person has a bruised ego.
Well, I'll say this. I hope that those situations you're referring to, the courts are just not taking an easy way out. A way to justify resolving the case when it may not be the best way to resolve a case.
Right.
We are very careful to make sure everybody understands that we are busy, no shortcuts. And even though I may have 15 cases on my docket today, that case in front of me is the most important case of the day, because it's the most important case to those individuals in front of me. So you have to really resist. Like, I got to find something here. And what I'm hearing makes sense when it really hasn't been explored or developed. So again, it's a teaching aspect. And I hope that what you're describing isn't a product of that. But, we want to do the right thing. I firmly believe anybody that puts their hand and takes the oath, raises their hand and take the oath, is swearing and committing, affirming and committing to applying justice in a fair, neutral, and appropriate manner. We afford tremendous authority and discretion in our judges, and it's extremely important in every case that we continue to earn that support and respect. And so we have to avoid finding a quick solution. A quick solution isn't always the right solution. There's a little cartoon that I've seen when we talked about parent alienation, because it's difficult. Those are complex issues. You could weave through the complex issues and get to the result, or you could take a quick path, but it may go off the cliff. And the diagram, it's just like a picture's 1,000 words. That to see that, look, yes, you want a quick path, but you may end up off the cliff.
Right.
And when confronted with this quick path, as opposed to a wavy road up a bumpy hill, there could, unfortunately, and hopefully won't be. And so the NCJFCJ has issued resolutions on this to tell judges that the obligation is to search learn, and not just get anything either. We don't use the term knee jerk. Don't get to a knee jerk, quick answer simply because you need an answer. These are very difficult concepts, especially if people are self-represented. You have psychologists, and then even if they are represented and you have two psychologists saying different things, this is a very an area that, if it's not navigated appropriately, really, and again, what are we talking about? We're talking about the well-being of children. We're talking about people's ability to parent their children. Implications, if you don't get this, you can look, there's no guarantee. You got to do the best job you can do. But if you're not studying and being advised of the best practices, if you're not aware of the latest research, if you're not aware of how to handle whatever it is you're handling, you can really cause harm. I mean, and judges have to really understand that and resist a quick soundbite answer, because we're dealing with human beings and children, and there are repercussions that will follow, or consequences that will follow those decisions. I guess where we start, where we revert to where we start to, Marianne, it's all about where our core is: training, education, awareness, making sure that judges go to conferences where we hear from people who have had an experience where they've been like totally shut down or railroaded. And that's what we try to do at the NCJFCJ. We have tremendous, we're really become the premier, in my opinion. Our conferences are the numbers of people that come out, and it's very important that, when people spend money and take off from work and fly to wherever we are, that they get something from it. It's not just socially, let's go to the sporting event. They have to go back to their jurisdictions, learning something, doing something different than they were doing before. That's what makes us successful.
Have you ever had a judge come to you and say, hey, I got this weird case, and I don't know, it's a he said, she said, and it seems like there could be some child psychological abuse. Do you ever think that maybe sometimes there should be two judges on the bench to navigate?
Well, I to be frank, I've never thought of that as a possible solution. Our system currently is not set up that way at the trial level. That's the appellate level, by the way. It's usually 2 or 3 judges. But that's kind of the role, I think, of a supervisor or presiding judge, to give the framework how the judge has to analyze a case. So the best practices, and Marianne, I'll tell you, a lot of time it is a he said, she said. We don't always have yet everything tape recorded and everything videotaped. And sometimes when you do, they don't tell the whole story. I explain it to, let's say 2 cars have a traffic accident in an intersection, and they both said they had the green light. Now, unless the street light with the traffic light was broken, somebody had a green and somebody didn't have a green. No tape recording there, no videotape. In that case, we go to a jury. Someone caused it. And so how do you do it? And so a lot of it comes down to being trained for credibility. A lot of it, in that case, they would look at how the car is hit, how the parties are testifying, any markings in the road, and they would balance all that out and come to a reasonable conclusion as to who did what to whom. And that's sometimes what we have to do, because I told you earlier, we're the jury. And so we have to understand now, a person may be nervous. Well, they may be nervous because they don't know what the judge is going to do. Or a person may embellish and say, Judge, I'm hit every day. Every day? Every day. Well, maybe they are, but maybe, if you're hit once or twice, if you're hit once, I don't need every day. But they don't know that. So they may be, I call it innocuous embellishment. So judges have to really understand or maybe they're incredible. Maybe they're making it up. So judges have to understand that, we don't live in a society where everybody takes a lie detector test before they come into court, assuming that would be valid.
Mhm.
So it's really about training and making sure that when that case comes in, if it's your first case or your 10th case, it's the most important case. Get a cup of coffee, get yourself together, and be on your best game to make sure your antenna's up, you're listening, you're not worried about your phone, you're not worried about emails. You're spot on, and we have to train that way so that judges, and then we talk to people with our real life experiences at our conferences, and again, and we get advocates in there. So if there's something we need to hear, they can help flush it out, and we have to be aware of red flags, and indicia of things. So it's they don't teach a lot of this in law school, by the way. And so judges have to really be willing to keep an open mind and learn, and things like that. And a judge like myself, I'm doing a whole new discipline than I did as a lawyer. So there's a lot of learning, and so I think that's how it is. So it'd be nice if we could have. I mean, when we don't have a system yet where there's a computer and you put the information in and the computer tells you what happened. Our system is you are entitled to, and the judge is obligated to be thoughtful, deliberative, neutral, informed, and to make sure he or she articulates what they're doing and why they're doing it.
Now, with your state, I don't know what your state does with these bad actors that don't obey judges' orders. Like, it's a continuous thing, and they're held in contempt, but then they get a slap on the wrist.
Well, again, I'm not here so much to talk about my state, but if you violate a restraining order, it's a very serious matter. It's brought by the prosecutor. On the second time, you're going to go to jail automatically, mandatorily, I should say. I am really emphatic, and I hope all judges are, that orders have to be followed. You may not like my order, but go appeal it. I don't say it in a flippant way like that. But until it's appealed or vacated, it has to be the order of the case, or we're going to have chaos. Really. And it's not an ego thing. Look, I'll tell you how to go file the appeal. I'll give you the papers. If you think you're wrong, we make it user friendly. I encourage the appeal. I want to make sure I got the right decision. But if someone is violating the order by not doing what we told them to do and getting away with it, we're encouraging further breaches of the order. And the next thing you know, they're going to show up where they shouldn't be and not allowed to be. So we do what we call compliance reviews. We also order services. If I have a defendant that's committed domestic violence, I could order services, batteries intervention, counseling, whatever is appropriate under the circumstances. And then what's worse is if I order it and they don't go and they don't do anything about it, because I'm telling them my orders doesn't mean anything. So we have to bring the cases back. We encourage a compliance review. I want to see in 1 month what you've been doing, and so that we can make sure orders are being followed. And I have an abuser out there. It may go on to somebody else.
Right.
So it's really a problem if orders are being blatantly violated with impunity. And so I guess again, every state has their own processes. I know as a national organization, we would speak in one voice that orders need to be enforced, they need to be reviewed, and need to have meaning. And again, it's not an ego thing because I said this. It's because if they're not followed, how are we protecting people?
Even if a judge orders psych evals, like in the family court, I don't know. It seems people should just already come in with their psych eval. Would that make it go smoother?
Oh, so here's a very interesting dilemma that I think about a lot is the lack of resources. Um, if you have the financial wherewithal, you're going to get me a psychological report. If you don't, how am I going to get that? Who's going to pay for this? Now, fortunately, we have some funds that we can access, but it also deals with your other issue of parent alienation, which concerns me a lot because people can make all kinds of allegations, and if I were able to have a staff psychologist here, I would get to the bottom of this a lot quicker with a lot less pain. And so there is a disparity that we see, and the administration or the outcome of justice should be in no way connected with the resources that the litigant brings to the courthouse. And so it would be wonderful if people could come in with an evaluation. But it's just some can and some can't. And, it does take a lot of my thinking and a lot of my time when I'm in a very diverse county economically. I could have in the same day cases where people really cannot afford the bus fare to get here. And I have people who, are outside of New York City, where we're located, have enjoyed the benefits of tremendous resources. The case is not one's not more important than the other, but I have therapists in the one case, perhaps dealing with the children who have seen something. I have whatever comes with that, and so I really don't know the answer to these questions. I'm just really kind of identifying the problem, and through an organization like the NCJFCJ, where we have judges from all across the country, we're in every state. We get a robust discussion because what I'm seeing is the same thing in some rural areas where there may not be a batteries intervention program, there may not be a drug treatment program, where there may not be a batteries intervention program in a non-English language. And we have to really figure out how to address that, because I think it unfortunately could affect outcomes.
Well, I know you have a National Center for Juvenile Justice in Pittsburgh.
Love Pittsburgh.
And I'm sure it's pretty busy in there. Can you tell me more about that?
We are so proud of the work we do. We are among other things, the collector of data, and as we've grown as an entity, data analysis is really is the basis for informed decision making. And so we warehouse and analyze for the experts on the juvenile data. And I'll tell you, in my short time, I'm on the bench 15 years, I'm in my 15th year, changes I've seen dramatically in the juvenile docket based on data and projections of data that comes in. There was a time when I first started that juveniles who were detained would come into the building every morning shackled. Young kids. That's not happening anymore. There was a time when our juvenile detention centers had no empty beds. That's not happening anymore. There was a time when juveniles could not shake loose their record from something that they did because of peer pressure or something along those lines as a youth, and it stayed with them. Our organization, by providing the data, is able to be part of discussions on reforms based on data. And so we are so proud of the work we do. I believe you're in Pittsburgh. I was actually born um, uh, 30 miles outside of Pittsburgh. And if I could put a plug in for my Steelers,
Yeah.
our facility is within 200 feet of the Steeler training camp. So every time I get to go to Pittsburgh, I walk by the Steelers training camp, and it just reinvigorates me. And so we're very proud of the work we do as a national leader on juvenile justice there.
I won't keep you all afternoon because I could. Did you ever have a case that totally creeped you out, that when you went home, you had the creeps and it disturbed you for 2 weeks?
Yeah, I would say the answer is yes. And I don't want to be dramatic, but it's really scary to me in some sense what people do to people, especially people who've had relationships with. Maybe they've been married, maybe they dated, maybe they had children together. And you think of all the high points that they may have had with the birth of a child or a marriage, and you fast forward, and the stuff they're doing to each other is I can't understand, like, how, I guess there's a lot of missteps along the way, but what people do to people, and that's the whole basis of domestic violence. When you have that familiar relationship, dating or something along those lines, sharing a child. I will tell you, when I first became a judge in this area, I would sit there sometimes and say, oh, boy, when I get home tonight, talk to my wife about this or that. 3 hours later, something else came in, and I'm like, forget about that. I'm on to this now.
Mm-hmm.
So that goes back to what we were talking about before with the burnout and the vicarious trauma. Our judges, this one in particular, I've had child death cases. And the reason we get those cases is because there's other siblings in the family that the state will take custody of. I've had domestic violence murders, and I've learned early on. I used to be in a courtroom that had video. It was the Appellate Division was doing an experiment, so where whoever spoke, microphone, the camera went to that microphone. So at the end of the day, if I wanted to look at what happened, I'd have a CD, so I could go back and visualize the parties. I remember I had a case where, domestic violence case, we entered a restraining order. Several months later, the defendant shot the plaintiff and in front of the children, and it was a murder. I knew the case, but I couldn't really picture them. I went on got my videotape, and in a million years, I guess I could say, it wasn't one that I would have put money on that something bad was going to happen. So you can never, ever judge anything. What do they say? Can't judge a book by its cover. You never know what case is going to go south. And, I'm not dealing with in-depth psychological analysis. And so that really causes you to pause, knowing what people can do to people and have done to people, that you have to make sure that if I have domestic violence, one thing we say in our state, there's no DV light. You have DV, there's DV, you need protections. So we want to make sure that we are there, the judiciary is there to, once we have an adjudication, to protect and make sure there's services. So the answer is yes, you do have horrific, and I don't want to, become insensitive or, make comments to get a oh wow factor, but there have been some very significant in our courthouse here events involving DV, child welfare, where children have unfortunately been killed, or DV victims have been killed by their abusers. So we put in place, if something like that were to happen, or when it does happen, it's not an if, it's when something like that happens. We have the NCJFCJ has community response that can help. Because don't forget, I have 20 other judges here in a very, unified administrative office courts. If I'm out in a county somewhere west, I may not have that. NCJFCJ wants to make sure we can help in a community response, help the judge, help the community. So that's kind of always out there with this docket, is to make sure that we have the training and servicing the clients, the litigants that come before us.
Well, I totally appreciate you for taking time to come on to my podcast. And is there anything else you'd like to add?
I'd like to say to you, if you're ever in this area, please come sit with us.
Okay.
Come sit in our courtrooms. I mean, you're doing a great service. You're addressing issues or getting the discussion going on issues. And outreach is very important. Our courts, for the most part, are open. Some of our proceedings are closed by statute.
Mhm.
And so, public can't come in, but it's important that the public, through you and others, understand what's happening in the courts and what we're doing to address these issues. So I would welcome you. Would love to have you as a guest out here. We have good delis I could take you to.
Cool.
But thank you for having us. And all my colleagues at the NCJFCJ share in our appreciation for the work you're doing.
Well, thank you. And how can people reach the NCJFJC?
Well, of course, we have a website.
Okay.
And it's I'd like to say award-winning website. I'm not on social media. The state police in my state tell us not to be, but we do have access, the organization, with Twitter, Facebook, I think Instagram, but certainly through the web. We have all kinds of materials that are accessible, and we're just trying to get awareness and education.
Well, thank you so much, Judge Katz. I totally appreciate you coming on.
Thanks for having me.
Well, don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I'm your host, Marianne Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth. Please join us again with Judge Katz in the future, possibly, and other exciting guests. Thank you again, Judge Katz.
Take care. Have a nice day.
You too.